talking a substantial amount on FINRA litigation, and I'm a 20-year FINRA arbitrator, so this will be fascinating to me. We'll be talking about the perspective of employment arbitrators, public policy, and lastly, we'll be talking about stakeholder perspectives. So once again, I strongly encourage you to use chat to raise any question you have along the way. And at the end, we will raise those questions to the panel. With that, I'll turn it over to Alex, and welcome.
Great. Thanks very much, Dick. I really appreciate being part of this panel, and looking forward to the discussion. I'm going to lead things off with a more overview type of presentation of what we know from the research in recent years, which really has kind of expanded our knowledge in this area over time. It was a little bit obscure, I think, in its early days, but we've really learned quite a bit more in recent years. I'm going to talk about the implications from a defense and plaintiff perspective, and then turn to some lessons, I think, from the neutral perspective from the research. Let me see if I can control it. I think I've got control, but it's not. Oh, there we go. Okay, there we go. So starting off with the question of, how big a phenomenon this is, where are we seeing it? And the answer is we're seeing a lot more of it than we used to. I used to do estimates of 20 or 25% in the early 2000s coverage by this, but my most recent survey, and it's a national survey the survey was actually in 2017, but found that a little over half of non-union workplaces had mandatory arbitration. So that's 60 million roughly employees covered, almost half of them with arbitration class action waivers. These numbers have probably gone up in the 3 years since that study, because this was right before Murphy Oil and Epic Systems, and so I anticipate growth of this. One interesting thing is where we see the most of it. We see large employers using employment arbitration the most. So I found 65% of employers with 1,000 or more employees. That's consistent with other research that did a kind of audit study looking at how many of the Fortune 100 had been involved in a case involving mandatory arbitration, which found 2/3 of them had. So it definitely seems amongst large employers. Among states, California and Texas, particularly high. That's something that we actually saw for a while. California used to be the kind of real center of it, but it's really expanded to other states now. I found 40% or more in all the 12 largest states. Interesting, used a lot in low-wage workplaces. That's, I think, when you look at large restaurants like Darden Restaurants is a big user, and some retail, we see a lot of activity there. Obviously, that's a center of class action wage and hour cases, so I think that may be some of the motivation there. Okay, let's see if I can get to the next slide. Oops. So from the employer perspective, what's the advice from the empirical research? That basic one, is it worth it for an employer? We're seeing employers increasingly do this. Is this a rational thing? I think the empirical evidence suggests yes. It certainly lowers time and process costs, which I think is something we've known about arbitration, but it still seems to be about half the time to get to a hearing than you'd find in litigation. Obviously that reduces process costs for the employer. They do get better outcomes. The research that we find, if you kind of average across all the cases, chances of winning or losing, the outcomes overall from the employer standpoint are lower award costs. So 25,000 across a very large sample of arbitration cases. That was all AAA cases for about an 11-year period. Litigation numbers in the sort of 150 to 300,000 range. When talking about that kind of question, people often bring up the question, well, yeah, but what if you go to arbitration and give up the summary judgment possibility that you can get in litigation? And that's something that I've looked at for a while. There's a couple of things that complicate that. People often focus on summary judgment litigation, say, well, yeah, you can get cases not done in litigation that way. What's often ignored is we see in the empirical evidence a real difference between post-summary judgment and pre-summary judgment settlements. Before summary judgment in litigation, settlements tend to be quite small, sort of nuisance value. But you see a lot of settlements after summary judgment motions fail in litigation, which tend to be quite high settlements. So you've got to play into that. The other thing complicating the picture is that we are seeing suggestions of an increasing use of summary judgments in arbitration. So some of you may have seen that in your own cases, that defendants are more likely to bring those. I looked at that with a former PhD student, Kelly Pike, in 2008, and it was maybe a quarter of cases involve a summary judgment motion. When Mark Gough and I looked at it in 2014, we found about half the cases involved a summary judgment motion in arbitration. My anticipation would be if we looked at it again today, it would be even higher. So summary judgment practice has been an interesting kind of growth area within arbitration itself. What does the empirical research tell us about the let me just move down here. The question of the design of procedures. So one thing that, one thing that we find is that most often employers are turning to the major service providers. The AAA is about half the cases that we see, and this is based on plaintiff attorney surveys, what they're encountering in their case. About half the time it's AAA, about 20% JAMS, about 15% some other provider, the kind of minor ones, and then 20% or so ad hoc procedures. So there's a fair amount of institutionalization. Couple of interesting things for procedure design based on the research that we've done. This is work I've done with Mark Gough, is we find that when the employer has had an in-house grievance procedure through which the case has gone before it went to arbitration, employers have greater success at arbitration. And we attribute that to the fact that these in-house procedures are resolving more meritorious employee grievances before they're getting to arbitration, right? So if I'm advising an employer, I would say, put those in because they're going to deal with, valid concerns by employees earlier on. Interestingly, mediation, we find that, mediation, as you might expect, increases the settlement rates before arbitration. Interestingly, we found it increases those outside of mediation itself. So if you've gone through mediation, even if you didn't settle at mediation, you're more likely to settle after mediation, but before you actually went to arbitration. So if I were saying how to design a good procedure, I'd say include grievance procedures and mediation. The plaintiff attorney recommendations from this are a little bit the mirror of the employer one. Plaintiff attorneys don't like employment arbitration. It seems fairly rational for them. If you look at the contingency fee calculation a plaintiff attorney is going to do, they're going to make less money out of arbitration than out of litigation. And Mark's done some research suggesting that they've got lower likelihood of accepting cases. Cindy Eslin at NYU has found that there are fewer filings in arbitration relative to where you can go to court. And so, that's the kind of missing part of arbitration. We're not seeing as many cases as we should expect when we compare to litigation. Last thing for plaintiff attorneys, this is a fruit flare, I think, for future research, is the mass case filing strategy, which we're seeing more and more of that. Really good recent example of that, DoorDash, the plaintiff attorneys there, where it's a class action waiver, filed 5,000 individual claims, which have a base fee of $1,900 that the employer has to pay. And that's not obviously the fee if there were an actual hearing, but just that initial fee. So that's $9.5 million. With tax, it worked up to about $11 million, which apparently DoorDash is not paying. So there's an ongoing battle over that. And we're seeing more of these battles jumping up. And that's sort of, be careful what you wish for on class action waivers is the big lesson there. The last area of recommendations is for the arbitrators. And here, let me get down to the next So here we've done some research. This is particularly stuff I've done with Mark on arbitrator decision-making tendencies, mostly using AAA data, but also some arbitrator survey data as well. And we find some tendencies in terms of decision-making. And what I'm going to suggest with these are really things that if you're an arbitrator are things to be aware that we're seeing arbitrators tending to make these patterns in their decision making, but obviously an individual arbitrator, if they're aware of them, can avoid these things, right? Because each case you're making an individual decision. So we do see suggestions of repeat player effects where employers who appear before an arbitrator more than once win more often. So if I'm appearing multiple times before the same arbitrator, I tend to do better. Now that, sometimes, that's just as bias. It could also just be adaptation, right? You figure out how better to appeal to that particular arbitrator, or you select someone, with more skill than the other side. However it happens, I think, again, this is one of those things that arbitrators can guard against themselves. That as an arbitrator, you can resist this tendency if you're aware of it. Similarly, Mark and I find that there's some career background effects. Arbitrators with a background representing employers tend to rule for employers more frequently. And this we find particularly amongst part-time arbitrators. This to us suggests the value of the true neutral arbitrator, who's a full-time neutral, and of making that really strong transition career-wise from your background, whichever side you represent, to genuine neutrality. Something that surprised us, but I think is worth being careful for those who are NAA members, is I went into doing a couple of studies expecting NAA members to be more employee favorable and found the exact opposite, that they tend to rule less often for employees. I still don't 100% know why. That's something that I've sort of thought about, but I don't really have a great explanation. Just to say that if you're a National Academy of Arbitrator member, maybe keep this in mind. Don't assume that you're necessarily the more employee favorable. You might be genuinely neutral, but the research seems to suggest that you're actually more employer favorable. So that's something to watch out for. The last consistent finding across decision-making tendencies is that self-represented plaintiffs do terribly. And so they tend to be also more vulnerable to things like repeat player effects. This is sadly something we see across a lot of forums. And so it's something that obviously I think needs to be handled with great care, is when you have the self-represented plaintiff before you. So all of these are things that we notice as average tendencies in the decision-making, but an individual arbitrator doesn't necessarily fall into these, right? And if you're aware of them, that helps guard against them in decision-making. So I think that's probably the biggest takeaway from this kind of particular set of findings here.
So thank you, Alex. You have raised some issues that will generate discussion at the end. This is very insightful, and I think many of us who do employment arbitration will want to explore some of your conclusions. So thank you again. And now we will move to Ryan and his discussion about FINRA. Do you need for me to give you approval? Yes.
Yep, just requested it.
All right.
Okay. All right. Yeah, thanks very much for including me in this really distinguished panel. It's a real honor to be here to present some of the empirical findings that some collaborators and I have developed over the years. I'm going to focus specifically on findings from FINRA research, so financial industry arbitration research, which I've been studying for about 10 years or so now. And so during that time, co-authors and I, particularly Dave Lipsky and other co-authors and myself, have asked a series of questions around FINRA's arbitration experience. And what I thought I would do today is give some insights based on those different studies in into how we can evaluate the overall effectiveness of the FINRA system. So I'm going to use actually the efficiency, equity, and voice framework to think about how we might evaluate the effectiveness of the system and what recommendations we can make. So just to give you a general sense here of where the presentation is going to go, I'm going to explain very quickly why we should care about the FINRA data, why financial industry arbitration matters, explain how we can evaluate that system using this efficiency, equity, and voice framework, and finally consider whether we can think about the the empirical insights on financial industry arbitration and what those sort of suggest for the role of arbitration. So why should we care about arbitration in the financial industry? Well, we know if we have any sort of basic knowledge of how arbitration is developed in the non-union setting, we know that the financial industry has been a key catalyst for that. So you can go back to Gilmer. Gilmer was a securities case. You can go back even farther to 2/3 of the Mitsubishi trilogy being derived from the financial industry. So as an industry, it's really been a pattern setter for a lot of the expansion of arbitration. And in Gilmer, for those of you that are quite familiar with Gilmer, you know that the court basically said, look, it's fine to arbitrate this age discrimination complaint as long as you have effective vindication as you would in the courts. And so that was really established through the financial industry and then expanded, outside of that industry in Circuit City. Aside from the sort of historical reasons to understand or dig deeply into the financial industry, we have to also consider that empirical data on arbitration are rare. Present company excluded, who have done, Alex and Mark, who have done terrific empirical work on this, it's quite rare to be able to get into these private forums and evaluate them. And so there's a data opportunity as well as a theoretical opportunity here. Let me explain why FINRA is a neat data set to use. So one advantage of the FINRA data is that you can identify all awards from the beginning of the system through however long you want to go. For the purposes of this presentation, I'm going to talk about a 20-year period from about 1988, the start of the system, through 2008. In addition to that, it's quite a rich data set. So what you have, as well as being non-truncated, you have data that dig deeply into the characteristics of the parties, the employers, employees, arbitrators, attorneys, and their law firms, as well as into the characteristics of, the cases themselves. Sorry, just give me 1 second. The cases themselves, the allegation types, how long they took, claim amounts, any motion practice, and then monetary outcomes. So out of all of this, we created a series of different models to test and evaluate the system. So what am I going to use in this presentation to evaluate the effectiveness of the system? I'm going to borrow, appropriate from Bud and Colvin, or from Alex's previous work on this, the efficiency, equity, and voice framework for thinking about how you can evaluate dispute resolution forums and systems. So 3 questions to ask. Is it cheaper and faster than other forums? This would meet the efficiency criterion. Does it provide a fair result for all the participants within the system or compared against other systems? This would meet the equity requirement. And finally, does it give employees access to procedural and distributive justice? This would be a voice requirement. So I'm going to try and articulate each of those quickly here for you around FINRA. So the efficiency criterion, let's take the time and cost aspect of efficiency. And this relates nicely to what Alex was just speaking to. So one thing you can look at is how long does it take you to get a resolution? Well, in FINRA, it takes about 18 months to get 17 months, a year and a half to get a resolution by the time you file it to the issuance of the award. By the time you have the final hearing session and you get award issuance, it's around 4 months between the final hearing session and award issuance. It usually takes around 7 sessions in total to get through a full case. And that's also actually skewed a little bit by extremely long cases. If you look at the median number of hearing sessions in FINRA, it's only about 4 hearing sessions before you get your final outcome. How does this compare to the court system? Well, we know from Eisenberg and Hill's study, and also from what Alex was just mentioning, that court cases take a lot longer, around 2 years or so, to get a resolution out of. So in conclusion, on efficiency, time, and cost, FINRA compares favorably. This fits in nicely with what Alex was saying. How about a second efficiency criterion? Is it flexible and adaptable? Well, we know FINRA in particular has evolved a lot, and I think other systems as well have evolved a lot over time. How can we define this? Well, we can define it by looking at changes to the system. So in FINRA, you had arbitrator selection changes. You moved from a rotational to a random selection process. You had arbitrator type changes, moving from industry chairs to public chairs. And in the case of discrimination complaints, at least, you had revamping of the way that mandatory arbitration would work, where in 1999, they moved from mandatory to voluntary arbitration for discrimination claims. So this is great. This is a nice level of flexibility and adaptability within the system. And I think it's much harder for the courts to do something similar. It's much harder for a court system to adopt new procedures based on expectations or problems within the system. So again, we can conclude, I think from this, arbitration in the FINRA setting works very well on flexibility and adaptability. So we've got flexibility. How about, we've got efficiency. How about equity? Here, we're going to look at how claims differ from each other. So one thing you can look at is whether within an arbitration system, win rates are relatively stable, or whether win rates depend on different aspects of claims that go into that system. You can look within the system and then across the system. What we've done is looked within the system, because looking across the system at equity is going to be really, really difficult. And I think Mark and Alex can speak a lot better to that. But I'm going to talk about within system variations in equity. So we know in FINRA that employees win about 60% of the time. And yet, when you look only at certain types of complaints, like discrimination claims, they win 10 percentage points lower than that. They win 50% of the time. So that's a materially significant decrease in win rates based solely on the allegation that you bring. Now, you might ask yourself, well, maybe this is because discrimination complaints are unique. They have some unique quality about them. Let's say, for instance, women bring more discrimination complaints to arbitration, and also women have been shown to do somewhat worse in arbitration. And so maybe the discrimination effect is actually just a gender effect. It's not really discrimination, it's other things. Well, empirically, we find that that penalty remains. It holds even after you account for the gender of the parties, the gender of the arbitrators, et cetera, even after you account for claim characteristics, et cetera. Why might this be the case? Well, it could be that we have an omitted variables problem, which is to say there are things going on in FINRA arbitration that deflate win rates in discrimination claims that don't exist elsewhere. There might be an anti-plaintiff effect. It might be that poorer employees take discrimination complaints. It might be that arbitrators use different standards of proof to decide discrimination complaints, and so that disfavors discrimination. Could also be a selection problem. That is to say, more meritorious claims can leave the system, and so maybe they do. Maybe they leave the system and go to the courts. Maybe the more meritorious employee claims get settled earlier because they have higher financial penalties associated with them if they get ruled against and if you're an employer. Or maybe they get bundled into class action suits, the most meritorious ones. Either way, you find discrimination complaints do worse. How about another measure of equity? Repeat players. As Alex noted, repeat players is a really common way of looking at within system and across system equity. Here you look at how experienced parties are in the system. And let me see if I can move this along, sorry. So you can look at experience within the system. And the problem, of course, is that only employers and arbitrators are repeat players. We have to think about why this is problematic, though. And this gets to Alex's question on repeat players. Is it that certain firms just have institutional advantages? You know, you repeat relative to other firms and you have larger resources to spend on arbitration, and therefore you do better because it's something about your firm? Or is it that firms actually learn to game the system? That is to say, relative to their past behaviors, firms improve over time. Well, we studied this question in some detail, and we found that the repeat player advantages, on balance, represents largely a resources problem, not a learning problem. Firms don't get better relative to their past behaviors, but they do better relative to other less experienced companies. Okay, so on equity, just to summarize, FINRA is weak on internal equity. Discrimination complaints are treated worse, and experienced firms exploit resource advantages to do better. But it's not necessarily weak on external equity. Courts, keep in mind, also treat discrimination complaints badly, and courts also have repeat player issues. So the effective vindication test isn't really necessarily disproven here between these two. It just means that that at least one, if not both systems are bad. Again, Alex and Mark can speak more to that second point. All right, the very last thing I want to mention, what about voice in FINRA? Here we look at the role representatives play. How do agents affect outcomes? So employees can bring attorneys into the process, and those attorneys can help counter any inequities that they might feel that they might face in arbitration. And in fact, this is the sort of S-Striker, Cadillacs versus rickshaws argument that says that access to high quality and relatively inexpensive attorneys is going to benefit employees in arbitration. That'll overcome equity issues in arbitration. You just hire a great lawyer and that'll solve your problems if you're an employee. Well, we looked at this and we found that essentially something like a prisoner's dilemma-like scenario emerges. That is to say that lawyers only really affect outcomes if the other side doesn't also have a lawyer. But the vast majority of the time, both sides bring attorneys into FINRA arbitration. So they're both incentivized to bring lawyers or attorneys into arbitration. And the effects is that those lawyer effects actually offset each other. Now, the problem here is that lawyers cost a lot more for employees than they do for employers. So employees pay a lot for representation. They must do that in order to counteract the employer's hiring of a representative. And yet the effect is actually muted by the fact that employers have representatives. But that's not to say that lawyers have no value to employees in FINRA arbitration. We do know that better educated lawyers, those that are specialized in employment law, and those that are non-self practitioners are valuable for employees. They do add value. So if you have these characteristics, you do help employees are helped by hiring lawyers that have these characteristics. So one conclusion from Voice is that you shouldn't assume that you can simply overcome inequalities in employment arbitration just by hiring an attorney. So to wrap up, to summarize here, we find overall from all these papers on FINRA, it does well on efficiency, it does poorly on equity, and it's somewhat mixed on Voice. It has ups and downs on Voice. What does this mean for controversies over employment arbitration? Well, certainly these systems don't overcome power imbalances. And in some cases, they might also add to them, although the addition comes from different aspects of those criterions for how you evaluate a system. It won't come from an inefficiency perspective, but it might come from an equity perspective. And the question that I'll leave you with is, does this mean the alternative is any better? And again, I can't speak to that in this research, but I know Mark and Alex and others might be able to speak to that better, but that's the sort of open and lingering question out of all this. Okay, so I'll stop there and thanks very much for your time.
And thank you, Ryan. This is absolutely fascinating for those of us in this area of employment arbitration. And I know it'll generate a lot of questions at the end. So with that, we're now turning to our third panelist, Mark Gough from Penn State University, and I believe you can see his screen share. Can I confirm?
I see head shaking, so I'm just gonna keep going.
Okay.
All right, thank you, Dick. Thank you, Alex. Thank you, Ryan. So I think Ryan and Alex's a large part of their presentations is what I would call, and perhaps a bit dramatically, but the arbitration researchers like white whales. We would love to find out these objective descriptive statistics or these descriptive statistics and be able to objectively compare them between forums, just like that last slide that I think Ryan shared, right? Well, does this mean this is any better? That all forums have their issues. And that's just very difficult to do for a number of reasons, right? just, well, hey, different people or different firms, different institutions have different forums, be it FINRA arbitration, right? Be it mandatory adhesive non-union arbitration, be it the civil litigation system, right? So first, a lot of firms select into those, and that just changes both the type of cases, likewise the parties involved. Likewise, every forum has their own unique rules, which is going to affect a whole sorts of things. And then, as Ryan also touched on, there are differences in representation and resources. And you throw all these together, and it becomes a very, very interesting, I think, stream of research, but also a very difficult question. However, the Supreme Court doesn't care. At the end of the day, great. Even if we had the perfect answer, guess what? Right, borrowing from Epic Systems, which was about kind of one-on-one, class action waivers. Basically, these questions are interesting as a matter of public policy, and but as a matter of law, the answer is very clear, and which is, right, a lot of these laws, arbitration, these forums, as they exist today, are legal, are appropriate. One way that I've taken, I've tried to sidestep this issue is both of kind of the difficulty of finding these objective descriptive statistics is by actually taking a look at perceptions of the forum from different stakeholders. And so some of my research has looked at perceptions from employees, from their attorneys, from arbitrators themselves. And I would love to eventually include firms, but they don't return my surveys. So that's on my to-do list. But again, they are most certainly a stakeholder and should be, included in this discussion. And I'm interested in the future of finding ways to get, good data from firms. So just to start with employee perceptions, and I'm going to restrict, I think I'm going to go back to what Alex was covering, which is the adhesive adhesive non-union arbitration, not necessarily FINRA. So it's going to be covering disproportionately low-waged workers, right? Women and minorities. And again, they're adhesive. They have no choice but to adhere to them. I am currently working on a paper with some very clear, I think, interesting findings that job applicants report very negative effects associated with this adhesive arbitration clause. So again, where it's not enough just to know, hey, that arbitration is, perhaps has issues, but how do its issues compare relative to other forums, right? Be it civil litigation, be it FINRA, be it AAA arbitration, et cetera, et cetera. And this study was relatively simple. We gave potential job applicants, people looking for work, kind of a short little vignette about their employer, about a fictitious employer, and we randomly changed what type of dispute resolution clause kind of was described, whether it was an adhesive arbitration agreement, whether it was a voluntary agreement, right? So they'd have choice, or whether kind of there's no agreement and it just says, basically you go to civil litigation. And to interpret these numbers, the higher, right, means basically the closer one is to 5, the better it is. The closer kind of the number is to 1, the worse it is. The worst potential job applicants perceive these forums. So using that civil litigation as that point of comparison, what we see is, well, hey, making these things voluntary has positive effects on employee perceptions of procedural justice, whether they trust their employer, and whether they actually would like to work for the employer as well. So this is interesting because it's not approaching this research from what kind of is legally tenable, or legally acceptable, which is Supreme Court, I think, basically, it's anything goes, right? They're very narrow, well staked out lines of demarcation, but they're very, very wide. It's pretty easy to stay within them. Yet there may be other ways of showing that maybe arbitration, right? There are equity concerns that courts aren't going to kind of regulate, but employers themselves can be convinced that this isn't in your best interest to pursue, because what ultimately happens, what you see is this adhesive arbitration lowers trust in employer, lowers the attractiveness of the employer, and lowers potential claimants' intent to pursue a job with that employer, right? And so regardless of what is absolutely true, we can say that, again, these effects are real, right? At least within the confines of the study, that that arbitration has, or adhesive arbitration has these negative effects on all these traits that firms should care about, right? And we as a society should care about as well. So next we can look at perceptions of plaintiff lawyers. And once again, plaintiff lawyers, I think it's, if there are any in the audience today, I'm guessing, right, I have a 9 or 8 out of a 10 chance of you kind of being in full agreement that our mandatory arbitration, adhesive arbitration, has a negative effect on things such as the fairness of outcomes, fairness of the proceedings, adequacy of discovery, and even their willingness to accept cases. So borrowing from, Ryan and Alex's mention of that Stryker, Saturns for rickshaws debate, that one of the trade-offs of arbitration, one of the most potent public policy, I think, issues in favor of arbitration is, all right, we may have to compromise a little bit on kind of fairness, on due process, but we're creating a much more accessible forum. And what some of my previous work implies is, well, that's just certainly not true, because the gatekeepers of these forums, which are lawyers, as Ryan said, right? You need a lawyer. Plaintiffs, particularly, if they proceed pro se, it's associated with very poor results. And mandatory arbitration agreements decreases employees' likelihoods of being able to obtain counsel. So, and specifically, in another study, it's that there's basically a 40% decrease in the odds that a lawyer would take their case, right? Likewise, when you related to that willingness to accept cases, this lawyers perceive a reduction of settlement value if there's an arbitration agreement. So they perceive a case taken to arbitration as being worth about 1/2 of what they could receive on behalf of their clients in litigation. And of course, because most attorneys, most plaintiff attorneys work on contingency fees, that their own pay, their own pay is going to be directly correlated with the settlement value. Which is the overwhelming majority, or I should just say it's the majority of dispositions. Yet an arbitration agreement has, they indicate that there's no effect on the perceived merits of a case. So again, simply introducing an arbitration agreement doesn't change whether they think it's quote unquote a good case or not, but it does change the likelihood that they will accept the case, and it will change the calculus, the decision-making calculus, because of reduced perceptions of reduced settlement values. All right, so we have, again, unfortunately, I don't have anything unique to say about employers. Hopefully next year, that can be a new contribution. But we've gone over employees, we've gone over employers, but actually neutrals themselves. And when I say employment neutrals, I mean labor arbitrators, employment arbitrators, and people that do both, right? even the neutrals, even the kind of the people running or central to the system, do not express strong confidence in it, right? So specifically, again, here, 1 is strongly disagree, 5 is strongly agree. So the larger the number, kind of the better their perceptions. So when we can ask arbitrators whether existing players such as JAMS and AAA, whether they adequately protect against the threat of arbitrator bias, whether they ensure adequate due process protections to all parties, whether they ensure every arbitrator on their roster is fully qualified and competent, what we get is something between disagree, either strongly disagree and disagree, or disagree and neutral, right? Nobody is expressing, or I guess I should say collectively, there is not strong support for these traits, which you think should be a given, right? We have a dispute resolution forum. We want there to be confidence in due process. We want there to be confidence in the procedural justice, but not only do employees kind of have skepticism, not only are the plaintiff lawyers skeptical, but neutrals themselves express what I would call skepticism, right? Likewise, one of the most interesting questions is, so we could ask arbitrators either whether arbitration is an employee-friendly forum and whether it's an employer-friendly forum. And again, across the board, they say, well, it's not friendly to either, right? It's an employee-friendly forum, unfriendly forum, and it is an employer-unfriendly forum. But if you look at the statistics, right, and this is statistically significant if you wanted to compare them, but relatively speaking, they think that it's a much more unfavorable to employees than employers, right? And again, this is directly from neutrals, right? You could argue, hey, asking lawyers, well, that's, you're asking to buy a sample. You could say the same about asking employees. To me, it's very hard to say, well, hey, neutrals themselves are biased against these forums. Additionally, at least for the JAMS arbitrators, and I don't have the statistics to show, but I asked the same question: if arbitrators had experience as a judge, so if they have experience in civil litigation, they got the same questions, right? That basically court is an employer-friendly forum, court is an employee-friendly forum, and we don't see the same relationships, right? And again, to me, that really should be a crisis of confidence in the system. It's here to stay. And I think that I don't think any of this is really an endorsement of the civil litigation system. It's not saying, well, hey, that's perfect. That's something we should not be critical of. I think we absolutely need to be critical of civil litigation as well. It has a long ways to go. But I also think because arbitration is here to stay, we can do better, right? We can do, as a society, better to elevate the access, the justice that is being rendered in this forum. Also, some potential explanations for what I just reported is, and specifically from neutrals' mouths themselves, are, my favorite is just talking about shenanigans, right? That neutrals basically are frustrated about shenanigans. And what could that mean? It could mean, well, employers are testing kind of legal thresholds for unconscionability. So bringing up that there are some mandatory adhesive contracts in the gig economy where they try to use the commercial arbitration rules rather than the consumer arbitration rules, right? And that is, I think a shenanigan is a great word to describe it. There are also, there were frequent reports of abuse of forum rules, where even though in writing the AAA, we could say provides adequate levels of due process, that means nothing if it's not enforced. So some arbitrators report, I mean, this one specifically is when an employer doesn't pay their proper fees, the case just evaporates. The AAA refuses to administer the case, and therefore the employee is left in the lurch, right? They'd have to take them to court to enforce the arbitrator fee. But again, that's just one more hurdle. And then I like to end also on suspect arbitrator providers. There's a lot of talk about JAMS and AAA, but I don't hear much about the dozens upon dozens of these startup arbitration providers. And I've included an ad here. And it's one of, this is an ad, mind you, for being an arbitrator, right? Maybe you're a stay-at-home parent who wants an interesting side project and extra income. Maybe you're starting your own practice or business and looking for contract work. Maybe you just want to get some judicial arbitration experience, or just plain think this might be fun, right? This is an actual ad for arbitrators from a company called Fair Claims. And so once again, I am, right, to even include, maybe you just think this will be fun. To me, that is not a qualification for being a neutral, right? That is not a qualification for administrating our universal kind of rights in the US. But I do think, again, things like this contribute to this crisis of confidence. And I think that's my presentation.
Thank you very much, Mark. What a tremendous number of issues to reflect upon. So we've got about 10 minutes, and we'd now like to move to questions. Chris Cameron, if you're still on, you had a question concerning, I believe, the difference in win rates between labor arbitration cases and employment arbitration cases. You want to speak up? You got to unmute yourself.
First of all, I want to say it was a great panel, and I don't know where to begin because I had questions for everybody. It was terrific. And I've read some of your research, Mark and Alex in particular, and look forward to reading Ryan's as well. Yeah, one question I had was whether, well, in my experience as an arbitrator, when it's a collective bargaining grievance and the grievance shows up without a union rep or a lawyer, that's a sign that the grievance is probably not meritorious and they're going to flail through. Is that the same thing in employment arbitration in your experience, or is that more likely a sign that it's just too expensive to get legal representation to navigate the system?
I think it's probably a combination of both of those. So, you see this sort of incredibly low employee win rate in, if they're self-represented. My first time working with about 3 years of AAA data, I read the analysis, and I found in cases with a repeat player and self-representation, there were no employee wins, right? It was like a 0%, which, everybody knows you get kind of loser cases being brought by people who just won't take the advice that their case has no merit. So you're going to see some of those, but 0% seems like, really, really low. I do think that kind of inability to get a representative, is part of what's going on there, right? And that's, it's always that calculation of the merit of the claim, but the inability of the plaintiff attorneys to take the cases, financially is a big issue. I've noticed a couple of times when I've presented the data to plaintiff attorneys, they're sort of interested and they sort of talk about the public policy stuff. And then afterwards, one-on-one, they're like, from my own business standpoint, this isn't going to work for me money-wise.
Just to also jump in on that, one thing empirically that you can do when you have a question like this is you can try to account for as many as many proxies for meritorious claims as possible. So, you know, differentiating between a good and a bad case, and then look at whether representation effects still hold after accounting for various case characteristics. Unfortunately, I think that from my experience anyway, the ones that I've used are sort of indirect measures of case quality. You know, you look at how much was claimed, you look at how long it took, you look at how complex it was, whether there's any dissent by an arbitrator. You know, these are, I think, reasonable enough in an empirical sense, but qualitatively, I don't know that they really speak as well to. I wouldn't want to stake my reputation in the field on saying this is, you know, this is enough to pick up all the different aspects of meritorious or non-meritorious claims getting representation. So I completely agree, and I just wanted to add that little sort of empirical strategy that you can take to try to help with the problem.
You probably don't need any more help in figuring out the questions, but it seems to me that the folks to ask that question to are the neutrals who do both types of arbitration and see what they say about it. I've done almost entirely collective bargaining and only now starting on employment, but you know, you can just smell it as soon as they show up without an advocate and are flailing away at figuring out how to make an opening statement and can't do cross-examination, and you know, you have to do a lot more work. And there's a reason for that. They often don't have anything to work with.
Yeah, and just to jump in that question too. So one way, what Ryan was saying about controlling for proxies is, again, to refer back to the vignette studies, where basically the case is the same, and so you don't change anything other than, well, hey, is this case going to arbitration or is it going to kind of civil litigation? And so one thing that I would stake my reputation on, particularly because I published it and my name's already attached to it, is that yes, lawyers are indeed, at least plaintiff attorneys are indeed, in theory, right, that that there is a unique effect about a mandatory arbitration agreement, which makes cases less appealing, i.e., which makes finding counsel more difficult relative to the absence of that case. But to say, but again, this is, it's hard to replicate that in the real world.
Thanks so much. This has been so great. I have to run to my next thing. I've already taken up too much time, but look forward to chatting with everybody in the future.
Thank you for the questions in the chat box as well. Much appreciated.
So Alex, the elephant in the room is whether DoorDash will end adhesion contracts.
Well, I think, you know, one interesting thing I've wondered is whether there'll be people taking the class action waivers out of their arbitration clause. You know, if I was advising an employer, I might actually think of doing that. You know, there are employers, particularly employment arbitration clauses that don't include the class action waivers. They're almost universal in the consumer setting. So like the cell phone companies, the credit card companies all use class action waivers, and the CFPB study is pretty clear on that. But in employment, that's not as clear. Like there's a lot of employers who haven't done that. And I actually could imagine sort of seeing that and thinking, you know, arbitration is worth it for me, but the class action waiver really isn't worth it.
A question for Ryan. I thought the FINRA rules carved out mandatory EEO claims. So do you know how many EEO claims actually are processed through the FINRA process? I mean, my personal experience is that the employment claims are contract-based. They're forgivable loan cases. I haven't seen an EEO case in FINRA in 10 years.
That's really interesting. Yeah, we've actually started, so we've started tracking this from actually more recent periods as well, from 2008 to present, with that sort of question in mind. You know, did all the EEO claims basically disappear? So that as of 99, my understanding, again, I don't work within the system, I just observe it. So, you know, there could be definite corrections here, but my understanding is that the claims were able to be carved out as of 99, and that from then on, you might expect to see some precipitous drop in the number of claims that go through the arbitration system. My empirical examination through 2008 suggested there was a drop, but it wasn't a drop to zero. It was a drop from about 18% or so to about 10 to 12%. And more recently, in looking at this from 08 onward, we found that that drop hasn't continued to decline. It's actually leveled off at a point where certainly people take claims out, but not everybody. And so, you know, that doesn't necessarily mesh with your experience, though. And I'd be curious, you know, about the qualitative experience of being a FINRA arbitrator versus what the data might show in terms of the cases that go through the system.
So we have time for one more question from the audience. Is there anyone? Otherwise, we'll just ask the three panelists if they want to share any final comments.
I think there's just a question that came in the chat from Ebek.
Oh.
Ebek, do you want to speak to the group about the question? Oh, got it. Okay, he says no.
Oh, sure. Well, that's something that, you know, Mark and I have done some work on, because, you know, that's obviously one of those things that you sort of want to think about, and it's something that we see in both the court and the arbitration cases is most of them settle. So we find, excuse me, that about 70% or so of the arbitration cases will settle as well. So settlement's sort of the predominant mode in both systems. It's hard because you don't observe the settlement amounts. That would be one of those things, again, as sort of a researcher, I would love some kind of, you know, disclosure law that, you know, parties wouldn't like it, but researchers would love, you know, you have to disclose all your settlements, and then we could take all that data and analyze that. But it is the one of those kind of great questions is what happens in the settlement cases. So some argue, you know, that litigation is better than it appears because you know, most people get something from a settlement. I have seen this one study that out of, I think it was like a Chicago district that got a hold of settlement data and found this kind of real effect between early and versus late settlement. If you get early settlement, it's nuisance amounts, but if you get later on in the process, if you can pass through, you know, settlement, summary judgment motions, then you get bigger settlements. So, you know, it plays off kind of, I think, both ways.
Just to add to that, because I think so it's important to think about settlements after they've been filed, right, as a disposition. But also, I think if you expand, if you think about the trajectory of a case from kind of just perceiving this incident, right, the naming, blaming, claiming literature. And I think, Abek, you are right in that. That's just one of the many things that's very difficult to control for, because many of these things can kind of settle, be resolved, you know, so maybe kind of resolved or not proceed to the next kind of dispute resolution stage is a better way to frame it, before they even register in these systems, which is one of, like, ultimately, again, this is why I describe these questions as the white whale, because you would need perfect information to truly be able to control for that. But there are, right, some assumptions you can make, some statistics, you know, you can model it statistically to account for some of it too.
And just one thing I'll mention on settlement is there is literature from legal scholarship, and this is, you know, settlement's a big issue for sure, and it's something that we all have to face when we look at outcomes. One of the arguments from the legal scholarship says that, you know, if you have a claim that goes all the way to an arbitration or a litigation outcome, both sides likely feel like they have a very strong case that's a winnable case. Otherwise, they would have settled at some point. One or the other would have settled at some point prior. So the idea is that by the time you get to outcomes, both sides expect to have a 50-50 shot at winning the case. Now, I don't think that's a good enough way of thinking about settlement. We need to do better, and it would be great to track claims as they go through the process, as we say. But that's one argument you can make for looking at outcomes and saying that, on average, both sides probably thought they had a shot at winning this.
Yeah, and to build on what Ryan's saying also, we know from the collective bargaining theory world that, bargaining outcomes occur in the shadow of strikes, right? Even though you mostly don't strike, you bargain, according to the theory, is based on, your potential bargaining power that derives from the strike. And you can view litigation settlements the same way. You settle based on what you think the outcomes in litigation are. Same in arbitration, right? So the actual outcomes then feed back in and shape the settlements, right? So the theory connects the two together.
And again, and that can be taken even back further, not just to settle, but your choice of whether to file a claim, right, in court, like how you're going to handle it. So before it even gets implicated in kind of what we are, I think, interested in, or at least what we've looked at to date, I should say.
This clearly could have been a 3-hour session, easily, or an all-day session. But on behalf of LERA and the dispute resolution section of LERA, we want to thank the panelists for some tremendous insights, and we're all clapping here. Where LERA is hoping to be part of a national conference on the future of ADR, and the question is, what will this research say in 10 years? What's going to change over the next 10 years from what we've just heard? And I wish that we knew. So if any of you have not yet joined the dispute resolution section of LERA, we ask that you do that. There's no cost beyond just joining LERA. Several people on this panel are in the leadership of the dispute resolution section, and we really encourage you, each of you, to become involved. So with that, we are done, and we've had a wonderful session, and we will make sure that we turn off the recording, and thank you all. Goodbye.
Thanks, everybody.
Thanks, everybody.